Well, hello, everybody. My name is Stephen Wood, and I am the director of the Center for Law and the Environment at Allard School of Law in the University of British Columbia. Welcome to a conversation on the availability of the necessity defense for climate and environmental protesters charged with crimes in Canada and the US. We're coming to you today from the traditional ancestral and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. Indigenous peoples, as I'm sure everyone here in the room and online is well aware, bear a disproportionate burden of the impacts of climate change, of the frontline struggles to protect land and climate, and of the punitive force of law enforcement and criminal prosecutions. So I would invite everybody here and online to think for a moment about the Indigenous land defenders carrying these burdens where you happen to be, and the Indigenous peoples on whose territories you find yourself. Folks in the webinar, feel free to, actually, does the chat even work in the webinar? I was going to invite you to introduce yourselves and the territory you're on in the chat, but that may not be a possibility. There should be a Q&A function, which you could use for that purpose. We'd really be interested in hearing from folks who they are and where they're coming in from. Let me just introduce the conversation we're about to have. So the basic premise is that facing an increasingly severe climate emergency and a rapidly closing window for collective action to avert the worst effects of global heating, individuals all around the world are reaching the point where they feel they have no choice but to engage in nonviolent direct action in defense of the climate system and the human and other beings. Please come in and join us who share it. And in defense of the Indigenous peoples whose land, air, and waters are sacrificed increasingly to prop up fossil fuel dependent extractivist economies. So these people are facing increasingly draconian laws and increasingly aggressive law enforcement tactics by industry, police, and courts. Many of them, when they're facing prosecutions for trespass, nuisance, criminal damage, criminal contempt of injunctions, have tried to invoke an ancient common law defense, the defense of necessity, to excuse nonviolent acts of civil disobedience. A few have succeeded, really only a few. Many have failed. A handful of courts in the US have acknowledged that the necessity defense should in principle be available to climate defenders if legal avenues for protest are ineffective. And they've allowed such defendants to put the necessity defense to the jury. However, no climate defendant in the US has yet been acquitted on this basis. In Canada, the courts are less receptive. In fact, in BC, they are downright hostile to the necessity defense for environmental protesters. Courts in BC have refused to allow tar sands pipeline protesters even to raise the defense to start with. The BC Court of Appeal ruled in our guest David Gooderim's case that environmental defenders have many alternatives available to them other than breaking the law, including simply doing nothing as the climate emergency passes a point of no return. The court has also said that the necessity defense should never be available to defendants who are trying to stop harmful activity that is legally authorized, such as construction of an oil sands pipeline or clear-cutting old growth forest. So today we're joined by an amazing group of people who are working on these issues. I'll introduce them briefly. They're all joining us online, and you can see fuller biographies on the event website. David Gooderim is a retired civil litigator who was charged with criminal contempt of court for peacefully protesting the Trans Mountain expansion pipeline on Burnaby Mountain here in Metro Vancouver. He was denied the opportunity to raise the defense of necessity, was convicted and served 18 days in jail. Dustin Clout, joining us from Calgary, is a constitutional and public law lawyer with his own law firm, Clout Law, and he was counsel to Greenpeace Canada in their effort to intervene in support of the necessity defense in David Gooderham's case. And that effort was rejected. Then from the US, we're joined by Alex Marquardt, who's the managing attorney, executive director, and co-founder of the Climate Defense Project, which is a legal nonprofit that supports and advises members of the climate movement, primarily in the US, and is also a leading advocate of the necessity defense in climate change cases. And finally, we're joined by Jan Hawken, who is a professor emerita at Portland State University, a documentary filmmaker, and the director of the two-part documentary film series Necessity, which follows Indigenous and non-Indigenous land defenders who, among other things, tried to raise the necessity defense in various court cases. So we're going to do this really as a conversation. I'm going to pose questions to the panelists, and it'll be a bit of a back and forth rather than a series of set pieces. And then there'll be questions time at the end. So first of all, please join me in welcoming our four distinguished guests. Thank you for joining us. I'm going to start with David Gooderham. So David, you were convicted of criminal contempt of a civil injunction that barred people from obstructing work on the Trans Mountain expansion pipeline, which is being built to transport diluted bitumen from the Alberta tar sands to the British Columbia coast for export. Can you tell us briefly how and why you found yourself sitting on a folding lawn chair blocking access to Trans Mountain's West Ridge Marine Terminal in Burnaby, BC on August 20th, 2018? David.
Thank you, Stepan. Well, this case, to begin, was focused on one large project, the TMX pipeline expansion, and on Canada's planned increased oil production, and trying to do that in the context of the global problem. That was the evidentiary challenge. I should point out that these events all unfolded began between March and August of 2018, when over 240 people were arrested. So more or less identical to my involvement and to my co-defendant, Jennifer Nathan, who was actually arrested in March, right at the beginning. So 240 people were flowing through the court system over the next 6 months. The difficulty everybody was facing was that this case was based on an injunction issued by the Supreme Court in favor of the company that was building the pipeline. And in a nutshell, because this makes this case a little different than some of the American cases, the raw efficacy of a judge's injunction order is that protesters, by the mere act of stepping within the prohibited zone, are deemed to have publicly deprecated the authority of the court. Reasons for protesting the pipeline are irrelevant. The crime is insulting the court. There's no right to trial by jury in Canada for breaching an injunction, and sentences were then quickly escalating to 7 days, 20 days, 30 days, and more recently 60 days. So it's been a severe use of the injunction. I was arrested in August 2018, well into this. My purpose, joined by Jennifer Nathan, was very specific by that time. It was to invite the court to examine a full evidentiary record showing the incompatibility between Canada's increased oil production and avoiding a catastrophic climate outcome. So we wanted to take this case and turn it into a full judicial hearing on the fundamental question. Was to, in effect, to use the judicial process that had arrested us to bring about the very hearing that had, and kind of public inquiry, rule of law process that had never happened over the preceding 9 years while this project was planned. So we were trying to, and the defense of necessity seemed to offer some possibility of that. and you in Canada, there have been a number of cases at the Supreme Court of Canada level on that defense. So there was a basis of judicial authority to try and explore this. I might say that our had no expectation that it would really be full success. I thought clearly it would have to go to the Court of Appeal level, and if we got one dissent, that would be a success. And even if we got a hearing on the evidence, that would be a success. So modest goals. And just to expand on that a bit, if I may, Stepan, that what made the defense of necessity compelling was the available evidence that was readily available. And I'm going to briefly touch on 4 threads of that. And I say compelling because each of those threads of evidence, I believe, if properly considered, were enough to terrify anybody about the path we were on. So the evidence is very compelling. And that was the evidence available in 2018. And secondly, the case was compelling because the evidence was so perfectly attuned for a full judicial hearing. By that time, the evidence available for a full court hearing or any kind of judicial inquiry was very rich and very clear. And I'm just going to highlight 4 threads, so we may or may not come back to these. One was the significance of Canada's oil production. We're the 4th largest oil producer in the world and the 3rd largest exporter, at least over recent years. Secondly, the significance of Canada's oil production in a global context. What we do matters in this country, however people like to think it's a small country in the scheme of things. And particularly on that, I mentioned the downstream emissions. So the emissions in Canada that we count officially are just a fraction of the full emissions from the oil we export. Then the 4 main threads of evidence that we drew into this case were first the evidence about the atmospheric carbon concentration level, which to my mind is a scaffolding for lawyers that is readily assembled and used in a judicial hearing. The Dutch case, the Urgenda case, had in 2018, the Hague Court of Appeal decision had shown how that evidence could be used. And secondly, just in brief, we had the UN emissions gap report then of 2017, which showed the alarming shortfall, the emissions cuts that had to be achieved by 2030. The IPCC 2018 report that came out incredibly on August 7th, 2018, a month before we filed our case. So, and it was an incredible body of evidence. And finally, there was by then some evidence showing the deep cuts in oil production globally that would have to be achieved by 2030 to meet any, even the most minimal goal. So the evidence was there, it was gripping, it could be put together, I felt, in a way that a court could work with. Indeed, the Dutch court had done it. And so that's what we sought to do. I will say one other thing about the background that's relevant in Canada, that by then about 7 or 8 years had passed since this particular pipeline project the process had begun to look at it. There had never been in all those years any inquiry, judicial inquiry, any kind of inquiry that had looked to see whether this project and the increased oil production was compatible with any climate goal. So that was important background in the case because it had to do with this argument that you had political alternatives. In fact, the political alternatives had been exhausted between 2013 and 2018. That was demonstrably clear. So I'll stop then and see where this.
Thanks, David. I actually wonder if you could help our audience and just share briefly what is the necessity defense in Canada and what did the trial judge and the Court of Appeal say about it? How did they interpret the necessity defense in your case?
Well, the necessity defense as framed in Canada up to that point, and there have been very few cases, but it has 3 elements. We have to show an imminent peril, obviously something of great gravity. In this case, it's obviously the climate peril. we had to show that an accused has to show they had no lawful alternative to avoid the peril. And in these simplistic examples of, say, a lost skier in the mountains who breaks into a cabin to save his life, that's pretty clear. He either gets into the cabin, breaks the law, and breaks into a cabin, or he dies. This is a more complex situation, but the principle's the same. And the final element of it, which is remains to be fully developed in the courts, is that the conduct disobeying the law must be, and the term used by the higher court in Canada in the past was, it must be involuntary. But that's in a very particular sense of involuntary. Involuntary in the sense that it was no true choice to obey the law. No person in conscience could possibly obey the law. And there's other ways of looking at it. Is that was the wrong of obeying the law greater than the wrong of disobeying the law? However we frame that. So that's the basic elements of the defense. The imminent peril then is obviously can only be conceived in terms of expert evidence assembled. And I would say that, and then there's a great deal of, if you will, rather finer judicial thinking in Canada about when has the imminent peril arrived. And the basic theme is that an accused need not wait until it's too late to act. So there's a time, a zone in there when you get right down to where the peril is so imminent that you are, if you will, the court would acknowledge that you would be in law entitled to disobey the law. So it's about time. In a nutshell, the trial judge, in fact, did what we wanted to see happen. He tried in his own, I would say, wholly inadequate way to decide whether there was an imminent peril. And I must say, he's looking at a summary of expert evidence that's 120 pages long. It's pretty complicated stuff. We didn't have actual evidence. We had a summary of expert evidence. And he said, the trial judge said that there was a contingency that business and governments will find a solution in time without any development of that. And there was no evidence in the record that could have provided a judicial basis for that finding of fact, if you will, a contingency. But at least his, I would say, hopeless attempt to deal with the problem sort of opened up the scale of what it is that we are dealing with. So we appealed that decision to the BC Court of Appeal. And he also said that we had a lawful alternative. And the one he identified is we could have applied to set aside the injunction. Well, our answer to that is setting aside the injunction would not have made any difference. The construction of the pipeline would still continue. So we went to the BC Court of Appeal, and here I'll just give you a brief summary of it and stop. The BC Court of Appeal, after a one-day hearing, concluded that we had a whole host of lawful alternatives. Could have stayed home in bed and done nothing. Could have engaged in the political process. They said that in a generic way. We could have brought civil litigation, and on they listed these things. My count was 6 or 7 or 8 things. But what they said in their judgment, which makes it quite an interesting judgment in a dark way, is they said they didn't have to look at, therefore, at the question of the imminent peril. They didn't have to decide if there was an imminent peril or when it would occur or what the timing of it was, because we had these lawful alternatives, which in effect is a casting aside of the whole essence of the defense of necessity. Because the concept, of course, is that you're compelled to act because of this imminent catastrophic thing that's going to happen. And our Court of Appeal said, we don't have to look at that. You had these alternatives, which means that even if it's already too late, you still have alternatives. So I'll stop there.
Thank you so much, David. I'll turn to Dustin. So Dustin, both Greenpeace Canada, whom you represented, and EcoJustice, Canada's largest environmental law charity, sought unsuccessfully to intervene in David Gooderham and Jennifer Nathan's appeal to the BC Court of Appeal. Can you tell us briefly why Greenpeace sought to intervene and what they hoped to contribute or accomplish as interveners?
Thanks, Stephen. I'm very happy to. Before I go and answer those questions, though, I just wanted to give a bit of a brief background on what interventions are for some folks that might not have, the education in civil procedure yet to know what those specialized forms of action are. When you're an intervener, you're not a party to a proceeding. You need to actively seek leave to make written or oral submissions. The process can vary greatly amongst various different courts. The BC Court of Appeal is on the stricter end of things in terms of their timeline. You're really only given 2 weeks after a factum is filed. So that usually requires some level of coordination with at least one of the parties. It doesn't always happen this way. And you've got to note that interveners are distinct from the parties. They don't always just say the same thing that the parties do. In fact, if they did do that, that's a reason that the court might not let them intervene. Typically, I've dealt with about 6 different interventions in various capacities before the Supreme Court of Canada and the BC Court of Appeal, both as counsel of record and behind the scenes. And typically, if you're at the SEC, you get 10 pages and 5 minutes of oral argument if you're granted leave. The BCCA, on paper, it's up to 20 pages, but typically it's between 6 to 10 pages. And it's not as common to get oral argument as well. They often will defer that to the panel, even if you're successful. So now that I've described a bit of that process, you've got to go in BC before one judge in motions in an application hearing to successfully argue that you should be allowed to intervene because you meet the test. And the test is essentially the same, some varying language, but it's essentially that you have some public interest, there's some public law matter or a private interest if you do have a private interest, a similar case. That wasn't the case here. Greenpeace and Eco-Justice, having intervened at many different courts before throughout Canada successfully, had a strong public interest standing to talk about these public environmental law, climate-related issues. That was one of the motivating reasons why they wanted to intervene. Others were that, in other courts in Australia, in the United Kingdom, in the United States, there had been some level of success either in getting this necessity defense before a jury or a judge, and actually in some cases, juries actually accepting the defense, although often with sparse reasons or no reasons being provided. But that was one of the impetus that my clients were thinking about, and just seeing how there would be nothing in Canada on this, or a relative dearth of jurisprudence on climate law matters generally. This was a good opportunity that presented itself. And, what I think they most hoped to contribute was to bring that international, at least from Greenpeace's perspective, global perspective, in that Greenpeace Canada is an affiliate of Greenpeace, is a global organization that has been involved with several of these other cases that have been successful. And they could bring to bear their expertise, both in terms of, putting before the court relevant foreign jurisprudence on this point, and also helping the court to decipher some of the complexity behind some of this client science, and to show that, many foreign courts, and indeed up to that point, increasingly so Canadian courts, had recognized the urgency of climate change, had recognized to varying degrees, the importance of looking to the international processes in terms of Canada's obligations under the Paris Agreement, in terms of the UNFCCC framework generally, in terms of looking at the Intergovernmental Panel on Climate Change's evidence behind the urgency of climate change. These were all some of the points that my client in their proposed intervention wanted to highlight to the court within the context of this narrow, what the court calls a Vukovic decision about whether an air of reality for this defense has been raised, to let this defense be put before a judge. So it was a combination of those factors that had motivated my client to seek this intervention.
Thanks. I wonder, thinking about either where you were then in 2018 preparing that request for intervention, or even now, what would you say are the key sort of problematic features of the court's approach to the necessity defense in the climate cases in Canada? Well, in David's case in particular.
Well, first, it's this heightened threshold requirement to not even put it before the trier of fact. And, you know, that was kind of what we had. You don't get to do a full submission. You get to do a summary outline of your submission that will then flush out if you're granted leave. But we started right away in on the fact that we wanted to draw parallels with the Ward decision from the Washington State Court, which we thought, you know, Washington is right next door. There's differences in the American law, but the elements of the defense are essentially the same. And that court relied on certain constitutional criminal defense rights in the United States that we thought there could be a parallel drawn in Canadian context. So we wanted to highlight that being so onerous and letting this go before the trier of fact could run afoul of, you know, the right to full answer and defense, which is established in Section 7. And we tried to suggest that, you know, in previous decisions on the necessity defense, like the Latimer decision of the Supreme Court of Canada, they had looked to charter values in helping to guide the defense. And we had kind of thought that was the approach that might say, well, no, if you're going to give this a full, fair answer in defense, or even more broadly in recognition of the equality or right to life, liberty, and security of the person's implications of climate change generally, you got to let this defense be ventilated on the full evidence. So that was kind of the first thrust that we were trying to connect that Washington decision back to the Canadian jurisprudence. And the failure to recognize any of that, I do think, was, in my opinion, incorrect. I respectfully disagree with the court. And also the court, in trying to decide this, tried to obscure, to my opinion, the question in trying to say, well, no, we're just talking about this Vukovic decision. We're not talking about the other substantive elements of the defense and whether or not we should be bringing in, you know, this IPCC science or recognition of international climate law or foreign decisions. They're not particularly helpful in this narrow Vukovic decision. That was their first point. We were trying to expand the scope of the argument. But it's kind of impossible to assess, you know, whether there's a legal basis, an air of reality for this defense that is relying on these very particular legal concepts that have been ventilated in foreign countries without recognizing that you have to go substantively into these considerations to some extent. And the court kind of, you know, washed their hands of that, at least at the intervention stage. And in looking at the decision which David had described, ultimately that came from the Court of Appeal, they really didn't go into the substance in the objective analysis of imminent peril or reasonable, you know, alternatives that were or were not taken that were legal. They didn't look to any of this evidence that we had suggested or to, you know, the foreign courts' considerations, and that was simply a failure. These are sources of evidence and sources of precedent that are available to the court, and at the very least persuasive and somewhat illustrative of some of these points by judges who had considered them in greater extent in those foreign jurisdictions. And I think it was a failure of our courts to recognize the utility of what was available and what we were proposing and what David and Ms. Nathan were proposing to bring forward to them.
Well, thanks for that. I can only imagine how frustrating it was dealing with that. Let me turn now to the US. Dustin, you mentioned a decision, the Ward decision from Washington State. It's one of numerous court decisions dealing with the necessity defense. So I'm going to turn to Alex now. Can you tell us briefly a little bit more what the Climate Defense Project is? And when you've done that, then let's get a little bit into the necessity defense. So if you could tell us a little bit the story of the Climate Defense Project.
Yeah, thanks. So you gave a little bit of background on CDP already, but we give pro bono support to climate activists and campaigns. CDP began as kind of a Hail Mary plan devised between myself and two friends during our second year in law school, as we tried to come to grips with the fact that we were graduating in a year and couldn't imagine doing the things people usually do when they graduate from law school. I had, with these two friends, already worked on a lawsuit against our university over its fossil fuel investments, so we were kind of already co-conspirators in that sense. We did start CDP immediately after law school in 2016. The only problem with that plan was that we had no experience and no one to really train us. I don't know if it's like this in Canada, but in the US, law school doesn't really teach you how to practice very much. So we were limited in what we could do, but we had heard about the climate necessity defense. It had developed some momentum already, starting with the Kings North 6 case in the UK in 2008. And then in 2009, when a guy named Tim DeChristopher used it in the US after posing as a bidder at an oil and gas auction. So this defense seemed perfect for us because no one else really specialized in it. We felt that we could kind of make it our niche. So we did that for a while. But one thing about the necessity defense is that you have to be willing to stand trial and take your chances with a jury, which in practice means that most people who argue the defense are relatively privileged, people who can afford to pass up a plea deal. So, usually we're talking about older white people. And we've been wanting to branch out a bit at Climate Defense Project. So recently we hired 2 new attorneys who have a broader range of experience in criminal defense. We can now work with kind of a more racially and economically diverse clientele. And we've been expanding beyond criminal defense a bit in recent years. We've started filing complaints in kind of collaboration with fossil fuel divestment campaigns at universities. This is sort of an obscure area of law, but obscure areas seem to be kind of our forte at CDP.
Yeah, well, I should say, because you mentioned it, what you and your classmates did at Harvard is really an inspiration for law students all around the world. So congratulations on having the courage to stand up to the university and challenge it to divest from fossil fuels. But coming forward again to the work that the CDP does, I wonder, can you just share with us, are there particular sort of highlights or successes with the necessity defense that really stand out for you in the US that the CDP has been involved with?
Yeah, sure. So in the US, when people use the necessity defense, they're usually doing it in state court. There is a version of the defense in federal court, but federal court is a little less friendly to criminal defendants in general. I think the necessity defense here, it's still rare to see necessity trials, kind of as David was mentioning. It doesn't happen that often because judges rarely rule to allow it. I think the kind of lawful alternatives element, which is the equivalent of the kind of involuntary requirement that David mentioned, that's always the most difficult hurdle, usually the most difficult hurdle here. But even when judges do allow it, prosecutors usually respond by dismissing the charges, right? They know that it makes it harder for them to win the case. And I think sometimes they don't want the defendants to have kind of the free publicity. But several cases have featured some version of a necessity defense here in the US. I believe that trial judges have ruled to allow it in at least 3 states, Washington, Oregon, and Minnesota. Not all of those cases actually went to trial. The Washington v. Taylor case, which sort of piggybacked off of the Washington versus Ward case that Dustin mentioned, did result in the Supreme Court of Washington State actually recognizing the climate necessity defense. As far as we're aware, that's kind of a first, not just for the climate necessity defense, but for any political use of the necessity defense. So that was a big moment. There was another case in Oregon a bit earlier, I believe that was a year prior, in which some tar sands protesters they had a mistrial. So 5 of the 6 jury members voted to acquit them after a necessity defense. But there was 1 holdout, and so the judge declared a mistrial. In terms of, challenges or difficulties, I would say a lot of these cases, again, you just see the fact that people tend not to argue this unless they already have fairly light charges or are willing to risk going to prison. So we haven't seen super long prison sentences. There was a case early on in North Dakota in which the defense was denied, the Michael Foster case. He did spend some time in prison. There was a case in Washington State in 2020 that resulted in conviction and a 60-day jail sentence. So again, nothing too serious. I think you know, a lot of times you do see in bench trials, judges denying the defense and finding the defendants guilty, but then not imposing any punishment, which again, I think reflects kind of this understanding or perception that protest is less harmful or less egregious than other kinds of criminal defenses, right? Which is understandable, but also potentially has some kind of racist and classist underpinnings. So anyway, that's part of what's going on. I think we're seeing that young people are a little less inclined to argue the necessity defense for reasons that we don't fully understand, but it seems, at least anecdotally, like young people are just not seeing the courts as sort of this area to deliberately incorporate into their overall strategy and just sort of trying to get in and out of the system as quickly as possible. But that's what I'll say for now.
Thanks so much. I really appreciate the context. I'm going to turn to Jan and just note, so as I said at the beginning, Jan Hawken is the director of this two-part documentary series, Necessity. By the way, I will show you, I'll show you the posters for the two slides. Let's see if this actually works. What did I just do? Oh, it worked. Okay, so you should see the posters, and as you're speaking, Jan, we can let folks look at those posters. So the two parts were released first in 2020, the second one just last year, 2022. And as I said, they follow these activists who invoke the necessity defense in jury trials. I should note, for those of you in the audience who are members of the UBC community, you can watch both films, stream them online via the UBC library website. If you don't have a UBC library account, you can watch them, or you can visit the www.necessitythemovie.com. They're very powerful films. I just wanted to ask, why did you make these films, Jan?
Well, I've been interested throughout much of my career as an academic, a psychologist, and a field researcher in the dilemmas of social movements, and particularly social movements that are attempting to engage in radical strategies, forms of social change with a social transformation vision. And so after the Standing Rock resistance against DAPL in 2016, early 2017, a group that many of you know as the Valve Turners were arrested and preparing for their jury trials. And I was asked to do a fundraiser for them at my home in early 2018, and I became very interested in the strategy, and they explained the necessity defense. I didn't feel that people there understood it very well, even though there's an incredibly exquisite logic to it that's very accessible versus so many legal strategies that involve kind of abstract legalese with dozens and dozens of references and briefs that can be hard for lay people to follow. The necessity defense kind of had a morally persuasive logic to it. So I thought, well, it would be interesting to follow the Valve Turners as three of them prepared for a jury trial in Minnesota. I reached out to the Climate Defense Project, so it's wonderful here to follow Alex today, because I was very interested in their work as movement lawyers, and even the the work of attorneys and people in the legal community around activism, which I think is not a commonly understood part of the legal field, how lawyers support activists in social movements. So we had the chance, my team and I, to go to Minnesota to follow the trial into October of 2018. And in preparing for that, I reached out to colleagues at Honor the Earth in Minnesota. I wanted to know how Indigenous activists felt about this legal strategy, which, as Alex suggested, is associated with people who have more privilege, who can weather the long course of it and fare better in the courts than do people of color. And the water protectors with Honor the Earth said, we support this strategy and we see this in solidarity with our work. Many of us have been arrested and hauled through the criminal justice system in ways that have exhausted us, and we welcome white allies who step in and in solidarity. So when my crew and I were there, we also had the chance and were invited to follow Honor the Earth water protectors as they guided us through that same terrain of the fight against the replacement of line 3 there and Enbridge, the fight against Enbridge Energy. So the challenge that emerged from that project was to weave these two stories together in the film, and that itself became a project where we were working with Indigenous activists, water protectors, who were guiding us through their story there in Minnesota, and also following the trial, which shut down, as Alex said, early on, as charges were dropped against the valve turners. When I came back to Portland, there was another trial that was scheduled against Zenith here, also using necessity defense. So
why don't you hand it up?
the second film continued that story of how the use of the necessity defense and bringing it before a jury could educate a broader community about the use of this strategy. What's the reasoning behind this strategy? So there are many lawyers and activists talking about the strategy itself, what led to it, how communities came together to support it. So both of these films ended up being about a jury trial, and has some of the drama of a jury trial, and is instructive in terms of the legal strategies that were deployed, but also they're both stories about love and commitment to place. One of the important, I think, ethical commitments of Indigenous knowledge is to emphasize our love and ethical and spiritual commitment to the natural world we inhabit and other living things. So we wanted that aesthetic to come through in both films. So they're both set in places where people care deeply about land and water and other non-human life forms. And they're also about people coming together to do hard things as communities and form alliances, and some of the tensions that arise as communities of very different social experiences and material conditions come together and fight for a livable planet. So teachers have really appreciated both films. We've gotten a lot of good feedback from K through 12 teachers, as well as university teachers, saying students students like the films, and they're not they're not downers to watch, but have a lot of inspiring and thoughtful people figuring out strategies for moving forward. So in that sense, I do see the films as a way of extending the principles of the necessity defense, with the film serving as its own a kind of cultural memory of this strategy, and to keep the thinking behind it alive, if not using the strategy itself. Because a lot of young people who watch the films talk about, well, I'm not prepared to use this, but they understand what's at stake, and the different ways that civil disobedience could be used that do not always involve the necessity defense. So there's been a lot of discussion at screenings of the films about strategies of resistance, including civil disobedience, as well as the necessity defense. So thank you for inviting me. And we had a wonderful screening. We had wonderful screenings in October at UBC of the films.
Well, thank you, Jan. We will open for questions shortly. I just wanted to circle back to Dustin and David and just give you the opportunity to reflect on basically what has changed since David's case was argued and decided. Have there been significant changes, do you think, in the evidence that's available to support the necessity defense, or in sort of maybe are there any cracks appearing in the law that might be hopeful in terms of the future success of the necessity defense in Canada? What do you think?
You want to go first, David, or?
Go ahead, Dustin.
Oh, he said to go ahead. Okay. In answering this question, I think there's factors that militate either way. So back when this was occurring, it was the pre-COVID, it was pre-Ukraine-Russia war. Those are two major geopolitical events that I think, frankly, have set back some of the wind that was behind the climate movement. And I'm hoping that we gain some of that back, because we didn't have any time to spare. And both of those have kind of taken some of that wind away, in the sense. In terms of developments in the law, I think it's positive to hear of that Taylor decision in Washington, a foreign court now definitively recognizing that defense beyond just letting it go to a jury. We've had the greenhouse gas reference in Canada. I do think that's a significant legal development, in the sense that, there is at least reference to the Paris Agreement. In several instances, there is recognition of the urgency of climate change that came out of it. The majority cited agenda on a very peripheral point, but we can take from that decision, some precedent that we should look at. The Supreme Court has looked at foreign case law on this. We should be able to look at it in various contexts. We should look to our obligations under the Paris Agreement. I would have liked to see some more reference to IPCC evidence in that decision. I didn't really see much on that. But it's setting the signal. I think the success of the necessity defense will rise or fall with the success of equating the charter to climate harms. And there are several decisions making their way through the courts. There's the Mather decision. We're waiting on a decision that went to the full hearing in the Ontario Superior Court of Justice. That's EcoJustice's case against Ontario for their inadequate climate targets. We'll see what happens there. That did survive a justiciability challenge, which has kind of been the bane of climate activists who have been litigated existence for decades now. There's another decision that just last month was at the Federal Court of Appeal, the LaRose decision. For our US folks, that kind of models the Juliana decision, that type of, in Oregon, that type of decision that failed on justiciability at the federal court, and it's being appealed to the Federal Court of Appeal. So we'll look to see what happens in those sort of cases. And if there is a definitive tying of the charter to climate-related harms, I think that will put some wind in the sails again. That might help with these sort of necessity arguments. It's going to be difficult in British Columbia with this precedent from the Court of Appeal, but that doesn't stop folks. Maybe try this argument in Ontario at some point if you've got compelling facts, a court that might be somewhat more sympathetic. It's certainly worth continuing to try to raise the necessity defense, but there's all these various factors, and it's hard to say. You also have to factor in the political situation in Canada, and the evolving nature of provincial and federal efforts towards combating climate change that can change the evidentiary record. To your second point, Stefan, on this, I think the record was there back when David and Jennifer litigated this case. I think the evidence has only gotten more damning about the state of the atmosphere. Certainly that evidence continues to be there, and it continues to be used in novel ways in foreign jurisdictions that we can look to as well.
Thanks so much. David, do you have anything you'd like to add? And don't forget to unmute yourself if you do. You're still, oh, no, I think you're still looking muted. Wonder if I can hear.
I got it, yeah.
Oh, he's back on.
Okay.
Okay.
Yeah, okay. Well, look, I'll add something here that, what's changed? I think the difficulty looking back at not just the trial and Court of Appeal decision in our necessity case, but also looking at the first two, the trial decisions in the two strike motions in the charter cases. I think the difficulty is not so much legal strategy or substantive law or the evidence. I think that the fundamental problem in Canada, in our courts, looking at our decisions, is the unwillingness and inability of our judiciary to question the social imaginary. That's to say, the worldview that they hold, their sensibilities, whatever word we want to use to describe that view of how our world works that we're so immersed in that it's very hard to look at it. And I think that, in fact, our trial judge's ruling in our case, where he said there's a contingency that society and industry will fix all this, it was a classic case of a judge simply accepting that the system we have is a sort of self-correcting system, and that it's not for the judges to fuss about that. And I think lying behind that is an overwhelming sense, not just in our judiciary, but in our whole political and economic, whole political culture, is to rely on economic analysis and economic markets and economic systems as the locus of where the real decisions will be made. And that it's not for the judges to interfere with, for example, what should Canada's future level of oil production be. So I think it's that inability of the courts to step back and take a hard look at actually the evidence. Now, Dustin mentioned the Supreme Court of Canada decision, and I think that is the sign of a crack in the ice. I think that judgment that looks at, ultimately concludes that every emission and every province's emissions are contributing to climate change, and their grasp of the concept of cumulative emissions was a major departure. And I differ a little bit with Dustin on the reference of the importance in that case of the Dutch case. I think that the Urgenda decision and the related Australian decision that they cite was in fact the scaffolding on which they understood the significance of emissions and the cumulative absolute limits that remain for us. And in short, why we have 8 years left to sort this out. So I think that amazingly, we had 7 out of 9 judges in the Supreme Court who accepted that and accepted it with a reasoned basis. And I think that encourages me that lower courts are going to have to roll up their sleeves and put aside that complacency about this which I think is a social problem. I look back at the profession I was in, the lawyers, my former partners, that whole world. It's no different than what you see from those judges still. So that's my comment.
Thank you so much. Well, I think we should open things to questions at this point. We're doing a hybrid event, so it'll be interesting managing questions, but there's already a whole series of questions on the webinar side of things that I can pull from. I would welcome anyone in the room to ask questions. If you have a question in the room, what I would suggest is put up your hand. I can call on folks to ask questions. And then before you ask your question, you'll see that somewhere in front of you on the desk, there is a little bump that is actually a microphone. If you press the button on that, a red light will appear, and then everyone online will be able to hear your question as well. While we wait for questions in the room, let me go to the first question online, which is from Sky Richards. And Sky asks, what do you think is happening with what has evolved in now calling land and water defenders or forest defenders terrorists? How can we combat that narrative and framing by increasingly authoritarian governments and the involving policies shaping public opinion? You don't have to look actually very far afield for examples of this, with the moves to enact critical infrastructure protection laws that put severe criminal consequences on anyone who, quote, interferes with or endangers critical infrastructure, such as pipelines. Does anyone on the panel want to field that?
Well, I'll add, if I may I jump in here just with a quick, I think this whole use of injunctions and the criminalization of the participation of people, including enormous numbers of Indigenous people in Colombia, criminalizing their effort to challenge this project has a big part of, we end up calling these people terrorists. And so I think that the use of the injunction, this free use of injunctions to a very severe and abbreviated process to deal with protest, is at the root of much of this pathology about the characterization of terrorism. Yes.
If nobody else wants to jump in, there's a question in the room, but also
I just had one thought, and that's,
oh yeah, go ahead.
Combating this phenomenon is less the role of the law and the litigator and more the role of the campaigner, and pushing, counter that narrative. It's about telling the stories, what Jan is doing, telling the stories about these folks and saying, these aren't terrorists. These are people that are just genuinely terrified for their future and the future of their children. And telling their stories, combating the narrative. Certainly, if there's any prosecutors who are trying to bring terrorist-related charges, we could push back legally. I haven't seen that to be the case, but it's, stepping up on Twitter and defending these people when people speak out against and label them as this, and pointing out the hypocrisy, because oftentimes these people calling them terrorists might also be anti-vax folks who are protesting and arguably using terrorism to and creating a public emergency here in Canada.
Thanks.
I'll just say that the terrorism label is a big problem here in the US as well. It's not new. It goes back, at least in environmental circles, it goes back to the 80s and 90s with some of the anti-logging campaigns. And I think it's, if anything, probably a good sign that folks are kind of threatening the powers that be, right? Because you see this whenever movements get strong enough. But it is a real problem with actual laws being passed in some cases and people being tried. There was a couple of cases in which the federal terrorism enhancement was used against some pipeline protesters in Iowa. So it is a problem, and I think, as Dustin said, it's kind of the role of the movement to build public support and use methods that don't alienate the public and go along with the government's efforts to cast them as terrorists.
Yeah, and you think of someone like Reverend Taylor in Washington. He and the others involved in their action were very careful to have safety measures and protocols in place to carry out their action in a way that didn't actually cause any property damage, and also that disrupted the rail line only for a short period. So you can see that I think it's probably on people's minds to carry out their actions in a way that doesn't invite that kind of characterization. Let's turn to a question in the room. You had your hand up. So see what happens when you press that button. And then if it's working, go ahead and introduce yourself and pose your question.
My voice doesn't carry.
I think go ahead. I think they hear you online.
My name is Kimberly Brownlee. I'm a philosopher based here at UBC, and I've done some work on civil disobedience. I had a few questions and addressed to some to Dustin and to David, but a few others to the whole group. One was whether you could say a bit about the reference to altruism in Latimer and I believe in Kirka as well. The BCCA references, when they're citing Latimer, they note the point about altruism, but then they seem to drop it in their discussion of that case. The second question, so it relates to a point that Stefan put up in the overview for this round table, and that is that the BCCA said that the necessity defense cannot ever operate to avoid a peril that is lawfully authorized by the law. And so I was thinking of Henry Morgenthaler and his success before 3 juries claiming civil disobedience and medical necessity in providing abortion care when it was tightly regulated. And of course, the perils of pregnancy are lawfully authorized by the law, but that doesn't change the medical necessity of providing abortion care. So I was wondering if I'm missing something in their characterization of lawfully authorized perils.
Kimberly, can I limit you to those two just now because we have so many in the queue, and we'll see if we have time to come back. Dustin or David, would you like to respond?
I'd respond on the second question. So lawfully authorized, yeah, it's tricky because one could argue, say, if you could say that, yes, it's authorized by statute or it's authorized by a judicial decree, but if you can challenge it on the basis of, say, the charter or some other higher ordinate legal principle, I would think that you could counteract that point. And what is sufficiently, legally authorized? It's a pronouncement that I think isn't just going to stand on its own. Like I think there is wiggle room to challenge that on the legal alternative. If you could make, say, a compelling charter argument or a compelling argument that there's conflicting duties legally, there's some common law basis for you to do this. As to the point about altruism, it's interesting. It's something I hadn't thought about. There's discussion of it in Latimer. Certainly it would go into perhaps, and unfortunately the course didn't really discuss proportionality, but it could be a principle that's weighed in the proportionality analysis at some point. Would it fit into imminent peril of altruism? I'm drawing a blank as to where it might specifically fit, but that's not to say that it might not. And in reasonable legal alternatives, again, I'm not drawing a specific example where you could maybe argue the principle of altruism, but maybe it's something that would fit into proportionality, or you can always, it's hard to do, but you can always bring an argument that you need to have some other principle basis built within the test, and altruistic motivations or proof of altruistic motivations, you could argue should be another factor to be considered in any event. I think it's open to people in the future. But I think the real keys are to continue to press, in my opinion, I'm a charter guy, so try to link this to the charter. If we get a foundational decision equating climate-related or environmental-related harms with Section 7 or Section 15, I think that's the foundation upon which we could really bring this back into the necessity defense through charter values, because it is a common law defense, and the common law defenses must, reflect charter values. That goes back to Dolphin Delivery in the 80s. Judges in crafting those common law, defenses need to follow charter values. And if we get the fundamental underpinning that this is a charter issue, that is the ammunition that is needed to hopefully shape this necessity defense moving forward.
Thanks. I should just note, we are starting to throw around case names and section numbers, and we may have a binational audience. So some of those are probably passing over people's heads. If you don't already know, Section 7 of the Canadian Charter of Rights and Freedoms is the right to life, liberty, and the security of the person. Section 15 is the right to equality. Latimer is an earlier case where a man who had caused the death of his adult disabled daughter tried to raise the necessity defense unsuccessfully. And Dustin mentioned a couple other cases, but that's all right. Can I go to one other case online and the question online, then we'll come back to your question in the room. So here's a question from Ben Holt saying, are there things that would make a Canadian case more defendable? Asking for a friend. One thing that, as you're thinking about that, one thing that I wonder about, there's a big difference in context between the Canadian and US cases typically. Most of the Canadian environmental and climate defender cases are cases of criminal contempt charges for violating an injunction that's been issued to a private party. And that's not common in the US as far as I know. More often in the US, you're charged with a crime that's set out in statute, like criminal trespass or property damage or criminal nuisance. I wonder in Canada whether folks think that people would have a better chance of raising a necessity defense if they were charged with, say, trespass or something like that, rather than finding themselves in a criminal contempt of an injunction type of setting. Just because of the stakes just seem so elevated for the judges when it's a criminal contempt case, and they just don't want to tolerate any kind of disobedience.
Completely agree, Seb. And there's different rule of law implications, right, in the two examples, in the sense that judges are wanting to defend their turf, and anything that's contumacious, they want to, disincent. So if it was in a statutory violation or a trespass related instance, that might be more helpful. Again, as I suggested, a different jurisdiction than BC, where there is now clear appellate precedent on this point. Some other factors, folks, the difficulty with the climate cases as well is, it's a negative externality problem. It's not an environmental issue that's like directly before you. Maybe the development of this in an environmental context where there is like an imminent spill or something like this as a stepping stone case. Someone has to act and turn off a pipeline, even though they don't have legal authority. I mean, this case probably wouldn't go to charge. I don't see why a Crown would if there was like a spill or something like that. But different facts like that might be used as a stepping stone could be another example.
David, did you want to add anything?
Well, I'd like to go back maybe to the fundamentals here. As far as altruism, Justice Dixon in the Perkett case very clearly made altruism as a foundation, could be a foundation for the necessity defense. And I think Dixon's, and it's interesting, that's a man who'd fought in the Second World War and I believe lost a leg in the war. He's of that generation who'd lived through Nuremberg. And I see in his judgment almost a mirror image of the Nuremberg principle. That Nuremberg, saying that you're obeying a law is no defense if you've committed a crime against humanity. And I think that Dixon was very clearly turning that upside down and looking at what happens when a law compels something that's beyond conscience. And if that's so, then I don't think we should be deferential at all about the fact that because the injunction concept is employed here, that it's going to be a no-go area. In fact, the judges, and I'm a former lawyer, so I can speak freely here, the judges don't own the rule of law. They are entrusted with managing the rule of law. And that in a case of the gravity that we're talking about, the fact that some judges issued an injunction should not be a barrier to raising a long-established common law defense. And perhaps the next case has to just fight through that. But I just don't think that deference to the injunction is the idea that it's a no-go area now. I don't think we should allow that to pass. And I add one more thing here. The idea of that because there's a law, you can't disobey a lawfully authorized project. Let us step back and look what authorized this project. It was an order in council of the Trudeau cabinet. But if you go behind the order in council, there was no rule of law process, no judicial inquiry that actually said this pipeline could be reconciled with any climate target. So the order in council was simply something that 30 people in the cabinet signed, and that became a law. But it didn't reflect any kind of judicial, behind it lay no process, no rule of law process that ascertained this was a safe thing to do. So if there was ever a lawfully based project to challenge, it's this one, because in my view, the order in council was deceitful. It was a dishonest order in council. It falsely stated that the project could be reconciled with our climate commitments. There was never a basis for saying that.
Thanks. Applause in the room, David. Do you want to ask your question now? So you know the drill, press the button, see the red light, go ahead.
Okay, thank you. Gayla Kesla, Nuguam Rainbow Eyes. I'm a member of the Dinakdao Awitlala First Nation. And on my father's side, I'm British and Scottish, and I was at the Fairy Creek blockade protecting the last of the old growth under the invitation of Elder Bill Jones, who is an elder of the Pachidat and the Dididat First Nation. And we went there to protect the last of their hunting and fishing territory. So I have 5 arrests, and we face judges with a lot of compassion. But other members, friends, and forest defenders, land defenders on the TMX pipeline, for example, they have faced judges that have no compassion. And we know that the judges, there's a judge in Vancouver who runs her courtroom like a totalitarian. And her name is Judge Fitzpatrick. And my question is, for the necessity of defense, what are the possibilities of bringing in our Indigenous laws and the natural laws into this? Because that is why we did it. We are all Indigenous. It's in our DNA to stand up for Mother Earth. And we want to connect this because going into the forest, it never connected into our brains. Number one was to protect the trees. We never thought of the next step. Now we're living in the courtroom. The courtroom is the new forest for us. This is where we gather, but we're having a hard time, even for myself, getting an Indigenous law specialist because legal aid will not cover it. It will cost hundreds of thousands of dollars. So we heard about this from our circles, and I know a lot of our friends are online, but we definitely need all the help we can get on how to bring in natural and Indigenous laws into the courtroom, and could it fit into the necessity defense? So yeah, Gayla Kesla.
Thanks so much. Oh yeah, and that'll help get the camera back. Thank you. Thanks so much for coming. Thanks for that question. Who would like to respond? And by the way, I think we only have time for one more question after this.
I could respond. Where it immediately comes to mind in the climate necessity context would probably be the reasonable legal alternatives. You could probably raise Section 35 rights as undercutting the validity of any legal order that might have, if there would have been an injunction in place, or if they say that you didn't follow the legal alternatives. I think that's the factor in the test where it might be considered. And again, if it doesn't neatly fit within there, you could just assert Section 35 as a special sort of defense. that would be a novel argument, but I would speculate that it is possible, if there is an established rights holder that is, it's not open to every Canadian, but someone who is of Indigenous descent and on their territorial lands where they do have Section 35 rights might be able to raise some of those arguments. I do believe there was a case that went to the SEC. I don't know if the decision was out, but talking about, like, there's classic cases. Sorry, Stefan, I'm gonna case dropping it. Beaver is the example, right? About trying to use Aboriginal Section 35 rights in a criminal context, in the context of a defense. There's a new case that went to the SEC or is going to the SEC, I think, talking about, it has a connection with Washington State. And I'm sorry, I'm drawing a blank on the nature of it. I might take a look and see if I can get the information on that case to the person. But you certainly can raise these arguments in a variety of different ways. And I feel your concern in that, legal aid isn't covering some of these various sort of arguments, and they are often complicated arguments involving complicated evidence about traditional territory and traditional Aboriginal rights and treaty rights in certain circumstances, depending upon where you are in BC. And it's a difficult case for the average person to marshal.
Shall we, I'll pose the last question, which comes from online, and I'll then give every panelist a chance to make a remark to wrap up. And I do apologize to the folks in the room and the folks online who have questions that we haven't been able to get to. The last one is from Norman Abbey, and it asks, is nonviolent civil disobedience the only tool available? I am thinking of Alan Borovoy's book, Uncivil Disobedience. Any thoughts on that? Lawyers don't want to touch that one.
Well, I'll just jump in here and say that I think a lot of these actions are motivated by precisely the perception that other methods have already failed, right? We're already in the middle of this emergency. And when David or Dustin talk about the courts having a certain mindset, that's the mindset in which you have to go through the normal political process. And we know, not just because of climate change, but because of all the other social problems we're facing right now as societies, and I think it's safe to say this applies both to Canada and the US, that those processes are pretty broken, right? I think sometimes people ask about alternatives to nonviolent civil disobedience, mostly to see whether property damage falls within that or could be an alternative or something more violent. I think there's a pretty strong consensus around nonviolence right now in all of these movements. And I think the necessity of defense has kind of grown up and come of age alongside nonviolence, right? As nonviolence has become the guiding strategy in most modern social movements. I think it's easier to use a necessity of defense when you're using nonviolent methods because it's easier to make that balancing of harms argument. But I think property damage it falls into sort of a gray area. There's a lot of debate about whether it is a legitimate part of nonviolent protests. And I think it's sort of the sort of thing where you have to make a decision in context about whether that furthers your goals and won't weaken the movement overall. I don't know if that answers the question, but those are my thoughts.
Thanks. Jan, do you want to just have the last brief word?
Yeah, when I started these documentary projects, I was stunned by how little my students knew about the history of civil disobedience and its role in progressive social movements. Almost any issue that we care to think about as part of the modern world, part of progress, has a history of civil disobedience. And I think during the Black Lives Matter movement, there was a lot of maligning of activists engaged in civil disobedience, seeing them as kind of running amok on the streets, especially here in Portland. But there is this side of the development of a necessity defense argument or case, as well as other forms of civil disobedience that require enormous thought, planning, trust, And so even the organizing and the activity around them, I came to see as kind of a form of prefigurative politics, ways people come together and think through strategies and confront power and overcome their fears, which is a big part of why it's so difficult to engage in mass action. People are often scared or feel hopeless or helpless about our plight. And so I think we need to reclaim the heroic and courageous and bold parts of our histories. And that's been a big part of why I think the stories are so important to tell in documentaries and other forms of storytelling, that they're not left behind. And students often are not aware of these histories, just as we're seeing now as these right-wing campaigns against so-called wokeism, any kind of teaching of progressive histories of people of color. We really need to push back and claim our histories and learn from them as well.
Jen, thank you.
Yeah.
We have an urgent necessity to vacate this room because there's a class coming in. Thank you, everybody, so much.